Kathy, you can go ahead and get started.
We go.
Peter, would you like me to get started or do you want me to wait at all?
Go ahead and get started. I'm already recording.
All right, perfect. So I'm going to start by sharing my screen because that's always my, my problem. So let me make sure that this still works. Okay, so can you see
Yes, we can see.
my full screen or do you see the notes with the next slide?
No, you're good.
You see the full screen. Okay, perfect. All right. So I want to thank Peter Klein of Let's Be Social 101 for hosting me to talk on what I hear is an important topic and what I emphasize as an important topic often with my clients, which is legal planning with or for your loved one with a disability. And to introduce myself, my name is Kathleen Hayes, and I am the owner and attorney of the law office of Kathleen D. Hayes in Glastonbury, Connecticut. And within my practice, I focus predominantly on planning for individuals with disabilities and their families. So this presentation is really focused on what I do day in and day out. And so my goal is to kind of walk you through what the types of legal planning considerations are that I might speak with each client about. Feel free to interrupt me with any questions, anyone. Okay, so in general, there are two tracks of legal planning, and I always emphasize this with any clients that we're always thinking, and families are always thinking in terms of planning for themselves, track one, planning for parents, and then track two, planning with or for, depending on the individual's abilities and engagement, a person with a disability. And so in this case, we're typically talking about a child with a disability, but sometimes we're talking about a sibling or a cousin or a friend. But for the purposes of this presentation, I imagine that we're talking about parents who have a child or an adult child with a disability. So what does it really mean for planning to exist in two tracks? Well, what we're typically talking about is that the parents have one track and they're focused on planning not only for themselves, but also thinking and being mindful of the planning needs of any children they may have, disabilities or not. And then the individual with a disability has their own track, just as everyone has their own track in life. And we want to make sure that we have those planning considerations, which are separate and apart from the parents' planning, borne in mind as well. So to begin, track one, planning for parents. Here's just a little bit of an overview. I apologize, it says track two, and I meant to say track one, planning for parents. So there is estate planning. That's a general topic where we talk about wills, trusts, and other planning documents, which I will get into in a moment. Typically, parents are engaged in public benefit planning on behalf of a child with a disability, because usually at the point in time that public benefits come into play, a child is usually in school or they're a minor. And so they're typically not engaged in the planning process themselves. And then succession planning. I talk about parents as pillars as they are in the lives of children with or without disabilities, and what that means in terms of the future if and when parents are no longer in a position to be those pillars any longer. So to begin, we're still on the parent track. I talk to families about estate planning. And estate planning when there is a child with a disability typically includes 4 documents and maybe 5 if the parents are going to have a living trust themselves. So we talk about a last will and testament. So that's the planning document that says, when you, the parent, pass away, whom do you wish to receive your property? What is your property, and who are you going to leave it to? And in some cases, it makes sense for a trust to pass property instead of a will. And that's something that you always evaluate on a case-by-case basis. So the will says where your property goes when you pass away. And if you have a child with a disability, one of the important questions is whether they might be on any sort of benefits now or in the future that have low financial limits, meaning that if an inheritance went to that child directly, the child would get knocked off of those benefits or they'd be ineligible. So I talked to families about third-party supplemental needs trust, which is the final document you see here. And later on in the presentation, I'm going to go over in detail the different types of special needs trust. So I just put that there as an important aspect of a parent's plan. And the other element with a third-party trust is that even though I'm often creating this trust as part of a parent's plan, sometimes this document can also be used by other people like grandparents, aunts, uncles, friends that may also wish to leave money to someone with a disability in a way where it's protected. And the other documents I talk to parents about are powers of attorney, which says if you're not able to make financial decisions or legal decisions for yourself, but you're still alive, who do you want to step into your shoes and make those decisions for you? And lastly, an advanced healthcare directive that says, if you, the parent, are not able to make your own medical decisions during your lifetime, who would step in and make those decisions for you? And it's really important for anyone to have a basic estate plan, but especially when a parent has a child with a disability, it's even more important because you want to make sure that the parent has set up a succession plan or named backup people to continue to make decisions that affect not only the parent, but also the child with a disability as well. Public benefit planning. So as I mentioned earlier, parents are often engaged in public benefit planning individually, meaning that their child is not always a real strong part of that process. And the reason for that is that we're typically talking about kids. We're talking about people that are too young generally to be really engaged in the planning process themselves. I wanted to talk about 3 critical benefits. There are more, of course, but these are the most central benefits that are accessed by parents generally on behalf of their child with a disability. So first and foremost, we have supplemental security income, and that's often called SSI. And what is it? It is a monthly cash benefit for individuals with disabilities. And Social Security defines what it means to be an eligible individual with a disability. So first they say you have to have a disability or some sort of medical impairment that's either going to result in your death within 1 year, or more typically that impacts an individual's ability to be substantially gainfully employed, which typically means competitively employed, working full-time at a competitive salary. An individual with a disability can still qualify for SSI if they can work, but generally we're talking about someone who is working maybe on a more limited basis. So in addition to having a disability or a medical impairment that's impacting work, the person also has to have $2,000 or less to their name. And I say in parentheses, except if we're using an ABLE account or a special needs trust, which I will talk about in greater detail later, because those are planning tools that basically say you can have well beyond that $2,000, but it's treated as if it's invisible and you can still access benefits. When we're applying or a parent is applying for SSI on behalf of a child, we're generally applying at age 18. And the reason for that is before age 18, the parents' money, the parents' resources are deemed or treated as if they're the child's. And so it's very challenging and in many cases impossible to meet that $2,000 resource limit if we're looking at the entire family's resources. So at age 18, an individual with a disability becomes an adult in the eyes of the law. And as such, any money that they have is separated from their parents. So usually that's the point in time when a parent would first apply. If someone's found eligible, the child gets a maximum monthly benefit of $794 a month. And I do say here, however, you're going to need a rental agreement in place in general if the child is living at home, because Social Security has this kind of archaic view where if you're living, where basically they say that this benefit of $794 a month is enough to pay for your food and for your rent. And so if your food or your rent is free because you're living at home and your parents aren't charging you rent, Social Security is going to say, well, then I guess you don't need the full benefit and we're going to reduce it by 1/3. So in order to get the full amount, if someone has a rental agreement saying, I contribute and pay rent, which may include food as well, then the individual is going to get that full benefit every month. So the next critical benefit that I talk to parents about is Social Security disability insurance. And I want to kind of caveat this and say Social Security disability insurance is something that can be available to an individual with a disability based on their own work record. If they've earned enough work credits, worked enough years in a row, put in enough hours and contributed enough to Social Security, and there's different formularies Social Security has for that. But if someone's worked themselves and then they can no longer work due to a disability, they can get this benefit. So that's separate and apart from what we're talking about here, which is known as the Disabled Adult Child Benefit. So this is a benefit that a child or an adult child with a disability becomes eligible for through a parent. So it's a cash benefit for a child with a disability that started before the age of 22. It's an entitlement. And what that means is that Social Security says you've earned this because you meet the definition. And because of that, there's no resource limit. There's no $2,000 asset test like we just talked about with SSI. It's a benefit that's based on the parent's work record. So when the parent has retired, or if the parent becomes disabled themselves, let's say they have a work injury, or they have an illness that prevents them from working any longer, when they start drawing upon a retirement or a disability benefit, a child who has a disability that started before the age of 22 gets 50% of that benefit without reducing what the parent gets. It's an entitlement. It's basically a bonus payment to that child. And when the parent passes away, that child's benefit gets bumped up to 75% of the parent's record. Generally speaking, when a child starts to receive Social Security disability insurance through a parent, their SSI usually goes away unless the parent's benefit isn't enough to make sure that that child gets at least $794 a month, in which case the child would get two benefits. They'd get a check from SSI and a check from SSDI to make sure that all together they're getting at least $794 a month. And that number, that 794, does go up with a cost of living adjustment every January. And last but not least, this is a beautiful benefit because after 2 years of being on Social Security disability insurance, a child with a disability will get Medicare as a source of health insurance. And that can be extremely beneficial, especially given various medical costs associated with disability. Last but not least, I want to talk about Medicaid. And I say this is Medicaid in a nutshell because Medicaid is quite the labyrinth. It could be a whole presentation, probably a week's worth of presentations on its own. But I do think it's important to have a general understanding of what Medicaid is and how it works. So Medicaid is two things, as I generally conceive it. And this is my view of the world. Different people might explain this differently. But Medicaid is a source of health insurance, primarily. That's typically what we think of when we think of Medicaid. This is health insurance for individuals that meet low resource limits, low income limits, low asset limits, or both. In addition to being a source of health insurance, it is also a source of supports and services for people with disabilities. So Husky A and Husky D are doors to health insurance. Husky A is the door to health insurance for parent caregivers, so parents of children that are typically up to age 18 before they turn age 19. Parents and those children who meet very low income limits can access health insurance through Husky A. Husky D is health insurance for adults who have very low income, who are 19 to age 64. So Husky D is another doorway to Medicaid health insurance. And lastly, we have Husky C, which is health insurance for people that meet low income limits and low asset limits. And it's Medicaid for people either who are over age 65 or who have disabilities. So Husky C can be another doorway to health insurance. But I do put two little asterisks here because Husky C is also the door to services and supports. So this is where we get complicated. And for the purposes of this presentation, I'm just going to plant some seeds. So when we talk about people with intellectual disabilities who have DDS services or services through the Department of Developmental Services, we're talking about people who have Husky C and are on what's known as a Medicaid waiver program, which is a source of supports and services for people with an intellectual disability. There are other waiver programs, all of which you have to access through Husky C. So for example, there are programs for people with brain injuries, programs for people that need hands-on assistance, programs for people with autism, though there's long waiting lists. And lastly, there's another program which is actually available to anybody who is in any of these categories, Husky A, Husky D, or Husky C. And that's called Community First Choice. And that's a source of services for an individual that needs support with activities of daily living, like bathing, dressing, transferring, let's say, getting up from a chair to standing, or someone with a disability like an intellectual or developmental disability that needs supports and services to be independent within their own living environment. So I often work with families that are looking for services so someone can be independent in a home, oftentimes when they're maybe transitioning out of a family home into a supported apartment potentially. We talk a lot about Community First Choice as a source of services and supports for that individual. So that's Medicaid in a nutshell, and those are the types of things that I'll talk to families about. Generally speaking, when we're talking about when are we looking at Medicaid, usually we think about it first in terms of, do you need it as health insurance? So I talk to parents about how long their child can be on their plan. Sometimes it's through age 26, sometimes it's throughout their lifetime, depending upon the employer plan, if they allow a child with a disability to remain on that plan past age 26, as is sometimes the case. So first, we talk about, when does the person need health insurance? And if they're going to need health insurance, but they're not going to potentially have an employer that they're receiving that insurance through, we talk about Medicaid. And then second, we talk about it as a source of supports and services. So usually a family is not going to be accessing Medicaid supports and services until an individual graduates, which now is 2022 as opposed to 21 previously. So that might be the time that we enroll in Husky C as a source of supports and services. So the timing of Medicaid depends a little bit in terms of when you need health insurance and if and when an individual is going to be accessing services and supports through Medicaid. And lastly, for the parents track, I talk about succession planning. So I say here, parents are pillars. And what I mean by that is in anyone's life, whether you have a disability or not, we're generally looking to our parents for everything when we're born. And as you age, and particularly as individuals with disabilities age, parents are generally the people that are in that primary support role. And they're the ones making medical appointments. They're the ones helping to apply for public benefits. They're the ones that are putting together any sort of inheritance, special needs trust planning. And that's all well and good, and that's often the parent's role, but there does come a point in time where the parents can no longer be those pillars. And that's just a natural fact of life, that as we age, illness may prevent a parent from providing supports in the same way or to the same degree they were providing them previously. And as people pass away, of course, they're no longer able to provide those supports. So my job is to try to work with families to talk about succession planning and to identify all those ways in which you as the parent are a pillar. And there's many subcategories, and of course it will vary depending on the family. And then trying to identify a network of other individuals and supports to be able to pass on that baton, to create new pillars, so that the parents have peace of mind that there is a plan, there is a succession plan that goes beyond them, and that they can pass that on, so that to the extent that their loved one with a disability requires continuing support, that they do have a place to turn for those various needs. I include here a letter of intent. This is a link. This is not my link. This is a special needs planning informational website, but I think that this is a very good sample letter of intent. And in essence, a letter of intent is basically someone sitting down and writing down everything that only they know. Medical appointments, doctors, what makes their loved one happy, what makes them upset, where can they find certain information. It's kind of that red book that in an emergency somebody can turn to and really understand and step in and see and kind of carry forward what a parent has been doing. But the best function of a letter of intent is not the red book plan that it's an emergency and now this is our resource, but it's a planning tool for parents to be able to start thinking about and organizing all of these various ways in which they're pillars, and then preparing to share that information in a planful way when a succession plan is being created. All right, track 2, planning with an individual with a disability. So there's a couple of different subcategories here as well. We have estate planning. We have wills for individuals with disabilities who are able to create wills. And then I have the spectrum of decision-making, which I'm going to go through, which is different legal planning tools for decision-making when an individual turns age 18. And it's a spectrum of options depending upon the individual's abilities, which are a spectrum. Then I'll talk about public benefit planning tools, which will include ABLE accounts and first-party special needs trusts. So we already talked about SSI, SSDI, and Medicaid as sources of supports and cash assistance. Because those programs, with the exception of Social Security disability insurance, which has no resource limit, but because these many public benefit plans have low financial limits, income and asset limits, An individual with a disability might need to make their own money invisible, in which case we have these planning tools. And last but not least, this is really similar to the succession planning for parents. We have future planning for an individual with a disability. And that might include transition planning out of the school, a plan for housing, a plan for what work or day supports look like, a plan for what the medical future looks like in terms of who are my doctors and do I live near them? Do I need to live near them, or do I drive? Do I live on public transportation to be able to access them? And a social circle. Who are my friends? Who is my community? And all of these different aspects of planning work together, because geographic proximity to your friends or to your medical doctors or to your job is important. And so an individual with a disability, in conjunction with their parents, other family, friends, or support members, or independently, should be thinking about all of these various aspects of their life, no matter how old they are, where they are in their personal planning. There's something to think about for the future, just as there is for all of us in our 5-year and 10-year plans. And the more that we can all think about and talk about what these things might look like in an ideal situation, the better poised everyone is to be able to actualize a plan, as opposed to being in a situation where you might feel like you're reacting to circumstances. So I want to talk a little bit about that spectrum of decision making. When an individual with a disability turns 18, they are an adult in the eyes of the law. And that means that absent any sort of legal planning, that they have the ability to make their own decisions, their own medical decisions, their own financial decisions, really anything. So there are different planning tools that often are talked about, and often the school brings them up when someone is turning age 18, because they talk to parents and they say, well, if you still want to be involved in the PPT process, your child needs guardianship or you need conservatorship. And that's something that we're trying to debunk, demystify in the world of disability, is that there is no one size fits all. And there's actually a spectrum of tools available to individuals depending on what their particular wants are. So I have this from the least to the most restrictive. Least restrictive meaning these are planning tools that an individual with a disability can create that keep them in the driver's seat, meaning they're the one making the decisions, to most restrictive, and most restrictive means other people, typically parents, are the ones in the driver's seat making the decision. Just because something's the least restrictive doesn't mean it's the most appropriate for every person. And likewise, just because something is the most restrictive doesn't mean it's the most appropriate. It's important to have conversations and figure out what is best given the individual's needs and their cognitive abilities as well. So the least restrictive, I already spoke about the advanced directive and the power of attorney when I talked about the parent planning. It's a legal document where an individual 18 or older is naming people to make medical decisions if they're not able to express their own wishes, let's say because you're in a coma. A power of attorney that says someone else steps in and makes financial decisions if you are not able. And lastly, I have a supported decision-making agreement. Supported decision-making is a new concept, and I'm actually part of the Connecticut Supported Decision-Making Coalition. And anyone that's watching this at any point in time can send me an email. My email is at the end of this presentation. If they would like a copy of Connecticut's toolkit to supported decision-making. It's something that was very recently released by the coalition. And it's a handbook that talks about what this is. And in essence, I explain supported decision-making as building upon the concept of natural supports, that we all have that friend that we go to for relationship advice or for money advice. If we're having trouble with a friend, we know who we kind of go and talk to for advice. So a supported decision-making agreement is a way to formally identify areas where someone might need support, and then to appoint a supporter to help somebody make a decision when those issues come up. A supported decision-making agreement keeps the individual with a disability in the driver's seat. It simply gives you a framework for making a decision by giving you a network of people that have said that they will support your decision-making process for different issues that might come up. A voluntary conservatorship of person or estate, we move along the spectrum. This is a planning tool where a probate court gets involved in the town where the individual resides. And this is a legal construct for people with disabilities that do not want to make personal decisions or financial decisions for themselves at a given point in time. And what they're doing is the person with a disability is voluntarily saying, I don't want to make certain decisions for myself, so I'm going to appoint someone else, like my parents, to make those decisions for me. And that if later on I decide that I want to make those decisions for myself now, because I voluntarily gave up my rights to make certain decisions, I'm also now revoking it. So voluntary conservatorship can be undone by the person with the disability by writing to a court and saying, I no longer want that conservatorship, and 30 days later, it ends. The most restrictive option for decision-making is involuntary conservatorship of person or estate or guardianship, which pertains to people with an IQ of 69 or lower that have an intellectual disability. These involuntary proceedings are other people, like parents, saying to a court, my loved one still needs assistance with making personal or financial decisions, but they do not have the ability to get that assistance themselves, most likely due to their capacity. They don't have the ability to make decisions themselves. And so parents or other people are asking that the court appoint them to make decisions for that person with a disability. So these are the various tools that are often considered, that I often talk to families about when someone turns 18, to figure out what the best path is for financial, medical, or other decisions that might pop up. All right, I want to talk about ABLE accounts briefly as one of those planning tools that makes money invisible. So once again, I always start with the why, which is if someone with a disability is on, let's say, SSI, that monthly cash benefit of $794 a month, that they have a low asset limit of $2,000, which means you can't have more than $2,000 in a checking or a savings account. So if that individual wants to save money, as many responsible people do, an ABLE account is a way for the individual to save money above and beyond that $2,000 or other low limits for different programs and still access those benefits. An ABLE account, by definition, is a bank account for someone with a disability. The disability has to have begun before the age of 26. And that account makes funds invisible for public benefits. These accounts are operated by the State Department of Treasury. And I say that because a lot of people ask me if they can go to Bank of America or Citizens Bank and open an ABLE account. And I said, well, no, these are actually bank accounts that are state operated by the State Departments of Treasury. Many states have ABLE accounts, including Connecticut. Connecticut is new to the game. They came on the scene about a year ago. And however, you as a Connecticut resident can open a Connecticut account, or you can open an account in another state that's open to non-residents, and many are. I have here a website that you can go to compare the features of different ABLE programs. However, every single ABLE program has to follow these rules that I put here because they're part of the federal law, meaning that these rules apply to every single state. So they're operated by the state's Department of Treasury. Anyone can contribute to the ABLE account, meaning the person with the disability can put their wages in or their saved up SSI benefit in, and parents or grandparents can contribute as well. The maximum contributions are $15,000 a year from all sources. So the cumulative tally for the year can't be more than 15,000. Unless the individual with a disability is working, then there's some circumstances where they can contribute some additional funds. The money grows income tax free, which is a wonderful advantage. So they're called a tax advantaged account. And the money that comes out of the ABLE account is tax free, as long as the funds are used for a qualified disability expense. And basically what that means is that the money has to be used for the person with the disability, and there always has to be some connection back to their disability. So a vacation is good for an individual with or without a disability for their emotional well-being or their social skills. So as long as you can draw some connection to that person's disability and the expense is for them, then chances are it's going to classify as a qualified disability expense. Rent, for example, is a disability expense. An ABLE account does have a payback provision. So what that means is that any state where someone got Medicaid services has the right to be paid back from any funds that are left in the account when the person with a disability passes away. So if there's nothing left in the account when they pass away, there's no payback. But if there is a balance and the individual did get Medicaid services throughout their lifetime, then the money is not going to go first to other named beneficiaries like siblings, but rather it's going to go and pay back the state for those services. I do often highlight that Social Security, SSI, does not have a payback. So it's really Medicaid. We're looking at Medicaid generally as a source of services, more so than Medicaid as a source of health insurance. So usually we're talking about, did you access some sort of program to provide you with services and supports through Medicaid? That's generally where the payback comes from. Okay, so this appears as a blank slide, but it is not. This is my attempt to be clever, and we'll see if it works. So I wanted to try to come up with some different kind of animated way to talk about special needs trusts, because this is a question that comes up often. So I have a series of clicks, and I'm going to endeavor to make this a dynamic explanation of special needs trusts. First, what is a trust? So it's always important to start there, because a lot of people kind of trailblaze through and assume that that's a really understood term. But if you don't know what a trust is, then as at one point I did not, you get lost from the beginning. So what is a trust? A trust is a legal document with rules that holds money or property for a specific purpose. So it has rules. It's a document with written rules about how the money or property must or can be used. It holds money, it holds property. So another question is, well, how does it hold property? Well, you execute a deed, you'll sign a deed document saying, okay, if I own my house, if I bought a house for my son or daughter with a disability, I want it to be in their trust. So you can transfer it by a deed to the trust. And now, because it was transferred in with the deed, the trust now owns the property. What about money? How do we connect money with a written document? Well, you can go and set up your ABC Trust checking account, and you can put whatever it is you want to fund into it. And you can also have an ABC Trust brokerage account. You can have multiple trust accounts. The question is, well, how do I know it's a trust account? How do I connect the bank account with the rules? Typically, either through your Social Security number or a separate tax identification number. So you sign a trust document. You say, all right, I want this trust to have these rules. I want the money to be able to be used only for these purposes. When I die, this is who I want it to go to. So you have your written document with rules, and then you get a tax ID number from the IRS, and you go to the bank with your trust and your tax ID number, and they set up the account. So the rules are connected to the account. What is the specific purpose of a special needs trust, now that we kind of have a better sense as to what a trust is? So we talked about supports and services. I think I look at these as kind of a beehive where all the bees go to get the supports and the services that they need. Medicaid is one of those supports and services we talked about, as is supplemental security income. So over here we have our person with a disability, and you see that they're a little honeybee and they want to go access the Medicaid, access the SSI because they need the supports and services. But you see this bee has money, and the money follows them to the hive. They're not allowed in because there are low financial limits to qualify for supports and services, and this honeybee has money, and that money is more than what those limits allow. Enter a special needs trust. A special needs trust is a legal document that makes money invisible. How does it make the money invisible? So we have the money in the special needs trust, and the special needs trust has special language in it that says that the honeybee, the money doesn't belong to the honeybee anymore. The money belongs to the trust, and because of the language in the trust, because the money is managed by someone else, the honeybee's money no longer follows it to the hive, and therefore they can access supports and services. The money is still there for the honeybee, but it doesn't follow them anymore. It's preserved and saved in the trust. There are different types of special needs trusts that have different rules. So the main two types of special needs trusts are first-party special needs trusts and third-party special needs or supplemental needs trusts. So first, the first-party special needs trust, who creates it? It can be created by the person with a disability, by their parent or grandparent, or a court. Whose money goes into it? Money that belongs to the person with the disability. We saw that honeybee, that was the honeybee's money following it to the hive. So a first-party special needs trust only holds that individual's money, not money from other people. So for example, it could be SSI that's accumulating wages of someone with a disability that's accumulating to those low limits, or maybe they received a settlement due to a car accident. All of that, those sources are things that could go into a first-party trust. Who is the trust for? It's just for that person with a disability. Who manages the money? The trustee. The trustee cannot be the person with a disability. So this is one of those ways and reasons why the money is no longer following the bee. It's because there's a different bee, a blue bee, that is now managing the money for that person's benefit. And when the trust ends, we have a payback. The state of Connecticut or any state where the individual received Medicaid is the first beneficiary of the trust. If there's nothing left in the trust when the person passes away, there is no payback. The other main type of special needs trust is the third-party supplemental needs trust. Who creates it? Anyone except the person with a disability. Whose money goes into it? Anyone's money except the person with a disability. So remember when we talked about the parent track, we talked about parents creating this trust as opposed to the individual. So gifts or an inheritance would be good examples of money that goes into the third-party trust. Who is it for? Again, it's still for that person with the disability, even though they didn't create it and even though their money didn't go into it, it is created for that person's benefit. Who manages the money? once again, a trustee who is someone other than the person with the disability. And the best part, what happens when the trust ends? Anyone named in the trust as a remainder beneficiary gets the money. There is no payback to any state that provided Medicaid supports. So to recap, a special needs trust is a legal document that makes money invisible so that an individual with a disability who has money, as we here, is financially eligible for government supports and services. So they drop their money off in the trust and they can access those supports. We have a first party trust created by the person with a disability, which holds their money. And then we have a third party trust that's created by someone other than the person with the disability that holds their money, all for the benefit of the person with the disability. And that brings me to the end of my presentation. To recap, we've talked about legal planning for parents on one track, as well as legal planning for their children or child with a disability on another track. And I think, as you can see based on this presentation, the two tracks really do parallel and even cross over with each other, that the more that everybody can be on the same page and communicate these planning steps, the better plan will ultimately result. So you have my contact information here. If anyone watching this presentation wants to give me a call, send me an email, you are certainly more than welcome to do so.
All right.
We'll stop sharing my screen. Do you have any questions?